All right, everyone, welcome to the 187 District Court. Happy Tuesday. Let's keep this a Tuesday. Let's not try to turn it into a Monday. These are the rules of the 187 District Court. You're in a courtroom. No matter where you are, you're in the courtroom. Whatever you could not do if you were in the courtroom, you cannot do on this Zoom screen. I don't know why I have to give examples, but I've found that when I don't give examples, people don't understand. So what does that mean? You can't be laying in bed. You have to be dressed appropriately. And by dressed appropriately, I mean that you cannot be wearing tank tops, tube tops. To all the inmates, you're not allowed to use the chat box. If you use the chat box, you're going to be sent back to your cell. Everyone who's on bond, if you don't behave professionally and appropriately on this Zoom, you're going to be required to appear today in the 187 District Court, which is at 300 De La Rosa. And what does that mean for you? That means, one, your attorney is going to come back, so you're inconveniencing your attorney. Two, you're going to have to drive downtown. Once you drive downtown, you're going to have to find expensive parking, or either you're going to get an Uber. So if you want the privilege of being on Zoom, you need to behave professionally. To all the attorneys, if you have a plea bargaining agreement, you will need to put in the chat box to Ms. Ferguson your agreement. She's the court coordinator. She's listed as Ferguson coordinator. If your client is on bond, we will need your client's email address. I'm going to open the breakout rooms. When I open the breakout rooms, it will invite everyone to a breakout room. Do not, I repeat, do not go to a breakout room unless I specifically call you by name and assign you to a breakout room. To all the defendants and those who are accused, I will not call your name. I repeat, I will not call your name. I will call your attorney's name. If you do not hear your attorney's name, that means that your attorney is most likely Zooming in another courtroom. They will be here shortly. So to all the defendants and those who are accused, when you don't hear your attorney's name, please do not raise your hand or call out, hey, I'm John Doe. I didn't hear my attorney's name. Because I've just told everybody, if you don't hear your attorney's name, they're zooming into another courtroom. Attorneys, this is the order in which you'll appear. If you see that you're low on the list and you want to go Zoom in another courtroom, you're more than welcome to do so. But if we get to your name and you're not here, you will be placed at the end of the list. Jonathan Watkins, Todd McCrae, Miguel Nahara, Bobby Gebbia, Jeb Locke, Phyllis Bill, Eli Rico, Rick Crow, Vivian Casares, Stacy Cross, Roy Barrera, Shannon Locke. Is there any defense attorney whose name I have missed? Okay, attorneys, when I call your name, I need to know the name of your client, and I need to know whether or not it's criminal trial division or family violence. At that point in time, you will be assigned to a breakout room. And to the courtroom, I know that Jim Toshi is in the courtroom. You'll be assigned to a breakout room. As you can see, there are more defense attorneys than there are prosecutors. Be patient. Consider that breakout room as when you go to a doctor's office and the nurse calls you to the back. You're not seeing the doctor right away. They're checking your weight and your blood pressure. Prosecutors have the ability to move throughout the breakout rooms. If you leave your breakout room, the prosecutor will see that that room is empty, and they're going to skip over that room and go to the next person. So everyone, put some patience in your pocket. Guys who are wearing your suits, I do realize that those suits have inside pockets. So put some patience there, put some patience in your pants pocket, and let's make today a Tuesday, not a Monday. All right, Jonathan Watkins. Jonathan Watkins.
Judge, can you hear me?
Yes.
Oh, thank you, Your Honor. Good morning. I have Michael Moreno on the docket. He has several indicted cases, and they're all family violence. Most of them are.
Okay. I'll send you to breakout room number 2. Todd McRae.
Good morning, Your Honor. I have Jonathan Greenidge. That's a CTD case.
How do you spell the last name?
Excuse me, Grinage.
And I'm sorry, you said which division?
It's CTD, Your Honor.
All right, thanks. I'll send you to breakout room number 3.
Thank you.
You're welcome. Miguel Nahara.
Good morning, Judge. I have Kevin Miller. It is a CTD case. We're here for a bond reduction hearing.
Have you conferred with the state?
Yes, Judge, I will. Well, I haven't yet. I'm happy to.
All right, I'll send you to breakout room number 4.
Thank you, Judge.
You're welcome. Bobby Gibbia.
Good morning, Judge. I have a PSI with you today, I believe, James Brewer. If I could confer and get a chance to look at the sentencing documents, I would appreciate that.
All right, if you'll put your email address in the chat box to CLO Reyes, she will get that to you. And is your client in custody or on bond?
On bond. He's on bond.
All right, I don't see him on the screen. And do you need to be in a breakout room with your client or the breakout room with the state?
Client, please.
All right, I'll see you to number 5. And Mr. Brewer, if you go to 5, I just found you on the screen.
Judge, it doesn't look like a PSI was prepared on that case. I don't know if one was ordered or not.
All right, was there a plea on this? Because I don't see a plea that was completed. Was there a plea done on Mr. Brewer? Does anyone know?
I might have my notes confused, but I thought we did enter into a plea.
All right, which cause number?
Just pull up my file here. James Brewer, theft 2020 CR 0778.
Yes, I don't show where a plea was completed on that.
All right, let me amend my file here. I will have to confer with the state then, please.
All right. Your client is already in number, if you could go to number 5 for me, Mr. Gebbia, and the person who is in 5, can you tell them to come back to the main room, please? And if you'll remain in number 5, and let me rename you.
Okay.
All right, thank you. And Mr. Brewer, we're going to have you remain in this main room. Jeb Locke.
Good morning, Judge. I have Haley Rainey, Criminal Trial Division.
I'm going to send you to number 6.
All right, thank you, Judge.
All right, and I think Haley Rainey got accidentally sent to 5, so Bobby Gibby is trying to move her out of that room to the main room. So I'll send you to 6. Phyllis Bill.
Hi, Judge. It's a CTD case, and I have not had any contact with my client. I was thinking maybe she was in the courtroom today because the telephone I have doesn't work.
All right, what is your client's name?
Oh, Kavonda Jackson.
All right, let me send you to a breakout room with the state, and we'll see if your client appears.
Very good.
I give everyone till 10:30.
Very good.
I'm going to send you to breakout room number 7.
Okay.
Eli Rico.
Good morning, Your Honor. I have Roger Villarreal, and it's a plea, and we're ready to proceed on that, Your Honor.
All right, I'm going to send you and your client to breakout room number 1 so you can make sure that all the paperwork is done. Roger Villarreal, if you'll go to 1, please.
Thank you, Your Honor.
And Eli Rico to number 1.
Thank you.
Sure. And to the clerks, if you could go to number 1, please. Rick Crow.
Yes, Your Honor, I'm here. I have Damon Mueller, and it's a criminal trial division.
You say Damon.
Mueller, Mueller.
I'll send you to number 8.
Thank you.
Vivian Caceres.
Good morning, Judge. I have Marcy Martinez, and it's with CTD, Your Honor.
And I'm sorry, what's the first name?
Marcy, Marcy.
Oh, like from the Peanuts. Okay.
Yes.
All right. Okay, the young people don't know what we're talking about.
I know. That's true.
All right. So number 9.
Thank you, Judge.
Where's Peppermint Patty?
Yeah, exactly.
Yeah. Stacy Cross. Stacy Cross.
I apologize, Judge. I'm here.
Yes. Who do you have?
I have Eduardo Escalera. He's present. It's a family violence case. And Judge, today you set my plea deadline for today because I had just gotten hired on the case 3 weeks ago.
Mhm.
And I'm here to ask you for a new plea deadline because I don't think that I'm prepared. I don't even have a plea offer yet, Judge.
Okay, well, that's odd that there's no plea offer. All right, I'm going to send you to
picked up
breakout
new
room.
cases, Judge, and I think that's why I don't have a plea offer yet because he's got unindicted cases.
All right, and these unindicted cases, is criminal trial division or family violence?
Family violence, it's the same thing that he
All
has.
right, I'm going to send you to breakout room number 10.
Thank you, Judge.
You're welcome. Roy Barrera.
Hello there, Judge. Good morning.
Good morning. Who do you have?
Yes, ma'am. I have Frankie Chacon, 2020 CR 0737.
Family violence or criminal trial division?
It's a misdemeanor probation. It's a probation issue, Judge.
All right, so it's the underlying case that he's on probation for. Is it family violence or criminal trial division?
Well, it's criminal trial, just a DWI.
Okay. All right, I'll send you to breakout room number 11.
Thank you.
Shannon Locke.
Good morning, Your Honor. Dustin Newkirk, CTD.
Thanks for changing your name. I'll see you to number 12.
Thank you.
Christine McDonald.
Good morning, Judge. I'm back on Tricia Hudgens from yesterday.
All right, just give us a second and we'll see about the update on the criminal history.
Okay, thank you, Judge.
Frankie Sandoval.
Your Honor, good morning. Aaron Crouch, family violence. It's going to be for a sentencing judge. And if you tell behind me, I would be Pigpen.
Hey, but Pigpen still got invited to parties, unlike Franklin. Just throwing that out there. All right, so your client is in the courtroom. Just give us a moment.
Thank you, Your Honor.
All righty. Tilden Schaefer.
Morning, Your Honor. I have Joshua Williams, CTD. We're still waiting for final approval, I guess, on pretrial diversion. Prior to the last hearing we had in this court, we'd filed the application.
All right, just give us a moment. We're going to see what's happening.
Thank you.
Okay. All right. James Toshi, I know you're in the courtroom. And your client, Brenda Vargas Carbajal, is that criminal trial division or family violence?
It's criminal trial, Judge. It's a DWI case.
All right. Have you had a chance to confer with criminal trial?
You know, kind of. I know that Mr. Nisbet is out of the country. Him and I have been chatting. He's aware of the violations. I can share our discussion with the court. But
sure, come forward.
You want to approach the bench?
Yes.
Okay. We have plea paperwork already presented. I don't know if you recall this case, Judge. During the plea, we became aware of the fact that she had an immigration issue. She has an appointment this week to visit with Melanie Lira regarding her immigration consequences, and we are due back to resolve the plea, I believe, next week. And so the violation report I do have, I've discussed it with Ms. Carbajal. I know she's had a lot of issues with this court, Judge. I can tell you what she's told me with regard to the latest one, if you'd like to hear it. And then I have a request that she's asking of the court as well that might really help things.
And what is that request that's going to help things? Because this is the 8th violation report.
Understood, Judge. So she has a job, and this is, I'm just going to tell you what's going on. She just oftentimes forgets to bring the device to work. It's not, I truly believe it's not because she's drinking. She's just very forgetful. So she has a lot of missed tests for that reason. And I told her that's really dumb. It can get you in a lot of trouble, especially in this court. But she just is a little bit absent-minded. She just got a car. And what she's asking you to consider doing is, now that she has a car, would you consider letting her use the interlock device instead? That way, it might be more fruitful in terms of her monitoring.
But have your client approach.
Okay.
Because I know a perfect way to solve her forgetfulness. You know what way that is, Mr. Toshi?
Have her put something on her wrist that says you have to keep blowing.
No, I mean, at the Bexar County Jail, you don't have to blow at the Bexar County Jail, Ms. Carbajal. You don't even have to remember to carry a device because you won't have the device at the Bexar County Jail. Will that help you out, Ms. Carbajal?
Not like I would like to. I mean, you know.
No, nobody likes going to the Bexar County Jail, but I've given you chance after chance after chance after chance. And I haven't even said chance 8 times, but this is the 8th time we've had problems with you. And so why shouldn't I have you go to the Bexar County Jail? Explain that to me. Why shouldn't I do that? And when I say, why shouldn't I do that? I don't want to hear, I have children to take care of, or I have a house, or I have an apartment, or I have bills to pay. You specifically, this will be the 8th chance, the 8th violation this court has had. So why should I give you a 9th chance to come before me again saying that you're forgetful?
Well, I do forget the monitor at my house a lot. And, you know, the times that I do go back to the house to go blow, it's a little bit over past time. And, you know, in the morning when I'm getting out of the house to drop off the kids, it's a little bit, you know, I'm in a rush and then I forget and I get out of the house. And that's why I told my lawyer if it would be, because I know I'm not drinking, you know, so I told him if it will be possible, because I just got a car yesterday and I would like to see if.
Have you been driving that car?
No, not yet, because it doesn't even have license plates yet.
So how did you get it home?
Well, my dad is the one that's been helping me out with getting it, and they went to pick it up yesterday from Austin. And so the car just got to San Antonio yesterday. It doesn't have no license plates yet. And that's why I asked my lawyer if we could.
But here's the thing, you're moving on from your violation to report to judge, give me ignition interlock. It's not even addressing the issue of the violation report, which is this is your 8th one. And I don't know if this is your 8th time of being forgetful, but again, we're back to my question. Why shouldn't I just send you to the Bexar County Jail? Because at the Bexar County Jail, there's no forgetfulness really needed because you're not driving.
Yes, I understand that.
So persons are protected. I don't have to worry about you tested positive for alcohol because you're at the Bexar County Jail.
Yeah, and I understand that.
Judge, she's got no good reason. I mean, let's just be honest here. What I can tell you is the most important thing is I don't believe that she's drinking. And I understand the court's position completely. We have no good excuses for you, but what I can tell you is I've been in constant contact with her. I do not believe that she's drinking. I think that's the most important thing to know. If the court wants to take steps that are more stringent to avoid jail, we're welcome to that. If you want to order the interlock as well as your mobile device, that's fine. Like I said, we do have a plea bargain. It is in place. We're hoping the court will follow it in a week. And so a bit of a large ask today, and I've told Brenda that. So we're completely at your mercy.
All right. Mr. Toshi, do you have other places you need to be today?
I do, Judge. I've got some other in-persons and a couple Zooms. Yes, ma'am.
All right. If you'll go do your other in-persons and then come back to the court, I'll make my decision.
Okay, Judge.
All right. Thank you.
Yes, ma'am.
Judge, I'm back from the breakout room.
Just one moment. Another attorney just zoomed in. Who is the latest attorney to have zoomed in? Speak now, forever hold your peace. Okay. All right. Who was the person who had the? Yes.
Sorry, it was on mute. I was talking.
That's okay.
Yes, I have Mr. Louis Gaitan on that one. We're not ready to confer yet because he was just indicted on the 7th, and we received some discovery on the 22nd. So we still have a lot left, a lot of discovery. We have the defendant's statement. We have 911 videos. We have surveillance video. There's a lot still missing.
All right. Just give me a moment.
Yes, Judge.
Is
he logged on? I was scrolling through.
Yes.
Okay. Thank you.
Yeah. Tilden Schaefer, Norma Ferguson on the Joshua Williams. Do we have a date for PTD?
Yes, I might send you a chat, Judge.
All right. We'll come back on your case on the 24th of August to get another update on the status of the PTD.
Okay, and Judge, I'm assuming you're probably going to be on Zoom at that point. I will be out of state, but I can Zoom in.
Oh, no, we will be on Zoom. I'm doing Zoom. I believe in protecting the public.
I have to ask because otherwise I've got a vacation letter on.
All right.
I hope to have it resolved before then.
All right. We will see you then. You and your client are excused.
Thank you, Judge. Have a good day.
Thank you. You too. All right. Todd McCray on Jonathan Greenwich.
Yes, ma'am. We conferred with Marcus Sanders. This will be my first setting. I would beg the court for a second setting to give me time to go over discovery and the offer with Mr. Greenwich, please.
Okay. Norma on Greenwich, can they have a 30-day reset, please?
The 24th as well, Judge.
All right. You and your client are excused. See you on August 24th.
Thank you, Judge. Thank you, Norma. Have a good day.
Thank you. You too.
And thank you, Marcus.
Norma, what page is Mr. Greenwich on?
Page 13, Judge.
Thanks. Jonathan Watkins.
I'm present, Your Honor. So I conferred with Mr. Garcia. State is still keeping the present offer. I had conferred with my client last time. He had rejected that offer, and I guess we just need to get with Norma to get some dates.
Yes, who's the prosecutor you were conferring with?
Mr. Joe Ray Garcia.
All right. If you'll go to breakout room number 1, please. Before you go there, just hang tight until Joe Ray Garcia comes back in. And then once you go there, Ms. Ferguson will meet you there to confer with a trial date.
Yes, ma'am. And Your Honor, there's one last thing I wanted to ask. We had previously had a motion to set bond. He's been remanded on 2 of the cases. If I were to file another motion, would the court be able to set that for a hearing too?
Yes.
Okay. Thank you, Judge.
Sure. So just give us a moment. As soon as Joe Ray Garcia comes back to the main room, we'll take that up.
Thank you, ma'am.
All right, Miguel Nahara and Kevin Miller.
Sorry, it took me a second to mute off there, Judge. I have conferred with the state. We're unable to agree to any sort of bond reduction amount, Judge. I filed this motion on the 22nd. I had spoken with his mother, who was going to be a potential witness. Unfortunately, I didn't get notice of this hearing until last night, close to 7 p.m., so I was unable to contact her to be present for this hearing this morning. If you want to proceed, I could certainly just ask the court to take judicial notice of his indigency status and the amount of time that he's been in custody on these cases. He's in on 2 cases. Oh, sorry, Judge.
Well, what we can do is, if you want, we can recall this. So you can have your witness here if you want a witness here, or we can proceed without your witness.
I'd rather have a witness here, Judge, so I could have something on the record, Your Honor, just as far as getting that together. I'd be ready as early as, I would ask just to give me an extra day, Judge. I'm helping my mother who just had a knee replacement surgery.
Okay.
And because of that, I may not actually make it into the office today.
All right, you want to do it for next week then?
Next week or even this Friday. I think by Friday I'd be able to handle it.
The problem is Friday, I'm speaking at a CLE.
Oh, very nice, Judge.
Legislative update.
Educate those
criminal
lawyers,
law.
Judge. They need
And,
educating.
Yes, and Ms. Ferguson will be receiving coordinator, what is it, Norma, coordinator training? I don't think she needs coordinator training, but I did not know this, but coordinators have continuing education courses the way attorneys do. So she has her courses on Thursday and Friday. So it'll have to be next week.
Okay, that's fine, Judge. I think it's courses for them to handle the post-traumatic stress of dealing with defense attorneys.
Okay. All
That's
right,
true.
Norma, what's a date next week when you set Mr. Miller for a bond reduction? You're on mute.
I can do it Monday, Tuesday, or Wednesday. Yeah. It depends on Monday. We can do it in the morning, Tuesday in the afternoon, or Wednesday in the morning.
Monday's fine. We'll take care of it Monday in the morning.
All right, so we'll recall your case then for August 2nd for your bond hearing.
Thank you, Judge. And that will be by Zoom as well, correct?
Yes.
Okay, wonderful.
And everyone, just so you know, you can go forth and tell everyone the 187 District Court will be doing bond hearings and all of our hearings by Zoom as long as we are allowed to do that. And if you all like, if you all like Zoom and having hearings by Zoom, you all should really let everyone know that you like doing things by Zoom. I know there are some good things about it, some bad things about it, but let everyone know. All right, your excuse, Mr. Miller, we're going to bring you back on August 2nd. Okay. Do you need to speak with Mr. Miller before you go, Mr. Nahara?
I certainly can, Judge. Well,
I think
he's gone.
sleeping.
Well, he
He's
didn't
like,
want to
I'm
talk to me.
done.
Understood. Thank you,
Trying to
Judge.
enjoy
Take
the
care.
rest of his week. Norma, you can let them know that L12 can go back.
Thank you.
All right, and Ms. Cavazos, I'll be right with you. I'm going in order of appearance.
Thank you, Judge.
Phyllis Bill, Kavonda Jackson.
Yes, Judge.
She's not in the courtroom yet. I give everybody till 10:30.
Okay. I conferred with Marcus and he's made an offer. And if I could just Zoom back in at 10:30 to see if she shows up.
Yes.
Okay, I will do that then.
All right, thank you.
Thank you, Judge.
Okay, Christine McDonald on Tricia Hudgens. Let me see if Marcus is. All right, just give us a moment. He's still in the breakout room.
Okay, Judge.
All right, Sylvia Cavazos, your client's name, please.
It's Louis Gaitan, Judge.
All right, Norma, on this one, can you give them a 30-day reset, please?
August 24th, Judge.
All right, so we're going to recall it. Yes.
If I may, I have an in-person docket call in Hayes County, San Marcos on that day. Would we be able to do it the following day?
All right, Norma?
Yes, ma'am. That's fine.
Yes, the 25th. Okay, thank you. I
Yes.
appreciate it.
All right, and so what I'll expect to happen on August 25th, for you to have all your discovery, and the state will be prepared to give you an offer at that time, or have they already
Yes,
given you an
ma'am.
offer?
They have not, no.
Okay.
I think right now I can't, well, it wouldn't be effective because I wouldn't have everything yet to so yes, that would be great. Because we just started receiving it on the 22nd.
Okay.
So yes, it's very recent. Thank
All right.
you.
We'll see you on the 25th.
Yes.
Have a good rest of your week.
Yes, Judge, you as well. Thank
All right, thank
y'all.
you.
Bye-bye.
And Mr. Gaitan, you're excused. Did you need to speak with your client at all? Ah, he's gone. People are leaving quickly. They're like, I'm done. Anyone else back from the breakout room?
I am back from the breakout room, Judge.
Yes.
I apologize for that confusion at docket call. It does turn out that my file indicated that we were set for a PSI today, but that was a mistake on our end. May I be placed back into the breakout room with state, please? I was talking to Meredith.
All right, if you'll just go back to breakout room number 5, but don't go to number 5 until you see Meredith McIntyre come back on the screen.
Oh, all right, sounds good.
All right. Kelly Piddle.
Good morning, Judge.
Good morning.
I have Brianna Mitchell. It's a CTD case. This was recalled from Friday because you all were in trial and I was in trial.
All right, who are you conferring with on this?
On Friday, I conferred with Marcus. Previously, I conferred.
All right, so, and have you conferred today or no?
No.
All right, so what I will do, I'll send you to a breakout room. I'll send you to breakout room number 14.
Okay. I got a directed verdict on my indecent exposure case, in case you're wondering. I pulled out the win.
Okay, look at Kelly Piddle trying to advertise on Zoom. Okay.
Saying.
Yes, I did hear about that.
I don't think you should use the phrase pulled out a win in an indecent exposure.
That'd be better.
Okay, let me see. Who do we have here? So David, on Sylvia Cavazos' client, Louis Gaitan, if her next setting date for that case is August 25th, so if you guys will be ready to tender her an offer by that date, please.
Okay.
And then let me see, who do we have else here? Okay, I'm going to start moving people up to different rooms now that I see where we are.
Judge, when you have a moment, could I see you in a breakout room with Shannon Locke?
Yes, if you guys will go back to 12, I'll go to 12 and meet you there.
Good morning, Judge. I was on the,
Ms. Phillips, I'm going to need you to be very patient. Your attorney is zooming in right as we speak. Okay. And then let me go to number 12.
Ms. Hudgens, please go to number 8.
He's just sitting there.
Oh, yeah, I see. Hi, Miss Ferguson, court coordinator. I got kicked out of a breakout room because my phone rang and my Zoom got kicked off. Is there a way I can get back in my breakout room?
What breakout room were you in?
I think it was 12, but I don't remember exactly.
Did you have somebody with you?
No, I was waiting for a prosecutor to come in at the time.
Okay. I'll put you in 11.
Thank you.
All right, Dustin Newkirk, if you go to breakout room number 12, please. All right, Jeb Locke.
Hi, Judge. I'm back from the breakout room conferring with Ms. McIntyre. We're requesting another setting so the prosecutor can contact their complainant and get a little more information on the case before they get back to me. And Haley Rainey, I'm sorry, I should have let you know.
Oh, no problem. So do you have all the discovery?
I believe I do, yes, Judge.
And did they tell you how long it will take them to speak with the complainant?
It did not, Judge.
Just, 2 weeks, 2 to 3 weeks is fine, Judge.
All right, Norman, can you recall Haley Rainey for 2 weeks, please? And we'll see where we are when we come back. You're on mute.
I can do it on the 17th, Judge.
All right, we'll see you back on August 17th. You and your client are excused.
Great, thank you very much.
Sure. Kelly Piddle, you still need to confer on Brianna Mitchell.
We conferred. I just conferred with Marcus, Judge.
Okay. So what is happening with Miss Mitchell?
Can we possibly go into a breakout room, you, me, and Marcus, please? Briefly.
No, I don't want to be called to a breakout room. All right. Let me see which breakout room you're in.
I can come down there if you want.
Yeah. If you guys would go to breakout room number 14. And Norma, if you can meet us in 14, please.
Hey, Meredith, can you meet me in 5?
All right, Stacy Cross.
Hi, Judge.
Yes.
So I do have an offer now from the state on these cases. And I just need some time to talk with my client about it and go over the evidence. And Judge, he's on full house arrest. So I need to ask for permission for him to be able to come to my office while on GPS.
And your client just zoomed in. Why was he late today?
He wasn't. He's been zooming in and out, Judge. He's just having, I think, some technical issues.
All right, Mr. Eduardo Escalera, where are you?
I'm right here, ma'am.
All right, Mr. Eduardo Escalera.
Yes,
if
ma'am.
there's a problem with your Zoom, then you're going to need to appear in court. Do you understand?
Yes, ma'am, I do.
So we're not going to do the zooming in and zooming out and driving around. You understand?
Yes, ma'am.
And the court does not allow driving and zooming. You understand?
Oh no, I'm parked, ma'am.
All right.
And Judge, he has permission to work, so that is why he's in a vehicle.
Yeah, but see, here's the thing about people working. It's like you can't work and come to court again. If you were in a courtroom, you would not be at work.
Absolutely.
So, yeah, so it's a privilege for people to Zoom, and people take advantage of privileges sometimes. Then they start saying, oh, well, I'm at work. That's why I'm doing this and that. So you're not allowed to be at work while you're on Zoom. I'm going to recall this, and I'm going to recall it for okay. I'm going to recall you. Norma, can I get a reset date for them for next Friday, August 6th, please? And to the courtroom, if you could go to breakout room number 4, please. Eddie Bravenik, if you'll go to 4. And Ms. Phillips, if you'll go to 4, please. And Norma, if you could have the deputy send them to 4. And Norma, I need a reset date on Eduardo Escalera for August 6th, if that's doable.
You said Escalera?
Yes.
August 6th. Okay, yes, Judge.
All right, that's your new plea deadline date. The court will not extend it any further. And Ms. Cross, yes, your client does have permission to consult with you on his case.
Thank you, Judge. I appreciate that. May we be excused?
Yes, but your client will have to let pretrial services know.
Okay.
And you'll have to call pretrial services and let them know that he's coming to your office, and they'll give you the time frames.
Okay. Thank you, Judge.
Right. You're welcome. You and your client are excused.
Thank you.
Marcus Sanders, are you here? I'm sorry, Miss McDonald. He's in a breakout room.
It's okay, Judge, but it was Mr. Garcia yesterday.
Oh, Joe Ray Garcia. Sorry, let me see if he's here.
I'm here,
Joe
Judge.
Ray, were you able to run a background check, criminal background check on Miss Hudgens?
Yes, Judge, and just confirming this is the only pending criminal case in her history.
All right. Okay, just give me one moment and we're going to take that up, Miss McDonald. David Woodard.
Good morning, Judge.
Good morning. Who do you have?
Judge, I have Jaquin Jackson. I've already signed the paperwork. I just need to get into a room with him to get him to go over the paperwork.
All right. I'll send you all to a breakout room. And
But
did you get the paperwork from Ms.
This
Ferguson?
morning. I'm sorry, Judge. What'd you say?
Did you get paperwork from Ms. Ferguson?
She just sent it to me while I was talking to you.
All right. I'll send you and your client to breakout room number 5. Mr. Jackson, if you'll go to 5, please. And David Woodard, if you'll go to 5. And we're going to go back on the record on Ms. Hutchins' case.
And Judge, may I update the court when you're ready on that issue?
Okay, just give me a moment. Yes. Yes, you wanted to update me on something?
Yes, Judge, I just wanted to let you know that yesterday after our hearing, I contacted Laura Duca with pretrial to let her know about this hearing and that the court is considering a bond reduction and or a PR bond on this case, Judge. She is already starting the screening process for both Cross Points and the ITP program through Haven for Hope. She got a medical release from my client yesterday and is working on getting her medical records to see if she qualifies. Both of those programs, Judge, they're 60 to 90 days residential. They have mental health help and services available on site, Judge, and I believe it would be an excellent place for my client to receive treatment.
Okay, so we're gonna go on the record. Court is calling NIMAG number 621069, State of Texas versus Tricia Hudgens. Can I have parties announced for the record for the state?
Joey Garcia.
For the defense?
Christine McDonald.
And are you Tricia Hudson?
Yes, ma'am.
All right, this is continuation from yesterday's hearing. All parties agreed yesterday to proceed by video. Is there any objection to continuing this hearing by video? State?
No, Your Honor.
Defense?
No, Your Honor.
Ms. Hutchins, any objection to continuing this case by video?
No, Your Honor.
All right, so the defendant is charged with endangering a child. The court has read State's Exhibits 1 and attachments, and those were admitted without objection. The court wanted to know whether or not the defendant had any other criminal history other than this charge of endangering a child. State, did you have a chance to review that?
Yes, Judge, I spoke to our investigator and confirmed that there is no other pending or other criminal history on the defendant.
All right, so the court is going to deny the request for a PR bond. So then the next question relates to the bond. Defense, what bond amount are you requesting?
Judge, I believe that if this client has an opportunity to bond out, I would have to try to coordinate with the TOPS organization. So that being said, Judge, I'm requesting a $1,500 bond if this court would allow it.
All right, State, any objections to a $1,500 bond?
Judge, the state would request a $7,500 bond. That's cut in half to what the bond is currently set out, and believe that's reasonable.
All right, State, are you remaining with a $7,500 bond, even if the court were to have GPS and for the defendant to be placed at one of these facilities, either Cross Point and what's the other facility, Ms. McDonald?
The ITP program through Haven for Hope.
Okay, if that's the case, Judge, we'll leave the bond amount to the discretion of the court for those conditions.
All right, and you say the ITP, P as in Paul program?
Yes, Your Honor. I believe it's integrated treatment program for both co-occurring substance abuse and mental health.
And will they be transporting her from the jail?
Yes, Judge. I believe pretrial handles that. We've worked it out with other clients before, Judge.
All right. Is there argument from either side? I know you all did argument at our hearing yesterday, but the court will hear argument if there's more argument either from the state or the defense.
I would like just to briefly, Your Honor.
Yes.
I know the state has brought up the governor's executive order. We've argued time and time again that that order is unconstitutional, Judge. And that being said, it does talk about people who have been convicted of violent crimes or threats of violence. I don't believe this case actually falls into that, Judge. I requested a $1,500 bond because I know that the Texas Organization Project has a limit on the amount that they can help an individual bond out with. I am optimistic that I might be able to use them to help her bond out, but I'm not sure, Judge. And any amount on this case, Judge, so just whatever you feel comfortable with, Judge. I'm requesting you lower the amount as much as you can so I can try to get this individual into treatment. This is the only case she's ever had, Judge.
Okay, and what the court will say, regardless of the governor's order, based upon what I've read in States Exhibits 1, and I believe States Exhibits 1 and 2, this is not appropriate case for a PR bond. What the court will do is the court will set the bond at $1,500. I'm going to ask for GPS. I'll ask that the fees are waived. She's to be transported. Let me do this, sorry. So there's to be GPS, full, waive fees. Defendant is to be released to either Cross Point or ITP at Haven for Hope only. Counsel, do you know if Haven for Hope will allow her to have a GPS or no?
I believe so, Judge, but I need to confirm with pretrial.
All right, I know for certain that Cross Point does. I'm not sure that Haven for Hope does. So that's why I put in the order that she's either be transported by someone from Cross Point or either ITP at Haven for Hope.
Okay.
And defense after your client, or if your client does well on GPS, of course, the court will consider, after you approach probably in about a month, the court will consider changing the full GPS to maybe something else.
Thank you, Judge.
All right. Is there anything else from either side?
I'm from the state, Judge.
All right. With that, we'll close the hearing. Do you need to speak with your client?
Just briefly, Judge, and then may I be excused after that?
Yes, but have your client come back to the main room.
Okay, thank you, Judge.
I'll send you to breakout room number 6. Ms. Hutchins, if you go to 6, please.
Thank you, Your Honor.
Your Honor, this is Miss Middleton.
Just one moment.
Yes, ma'am.
Yes, Sunny Middleton.
Yes, ma'am. I'm sorry I'm late. I've been in jail court all morning. If I could have a breakout room with the prosecutor. This is a criminal trial division. I believe it's Marcus or Tom.
What is your client's name?
Vanderstein Peyton.
All right, I'll send you to breakout room number 7.
Thank you, ma'am.
Okay, Eddie Bravenet.
Yes, Judge. Can you hear me?
Yes, I can hear you.
Excellent. So, Judge, I spoke with my client, and I think it is fair that she's having a bad day. That having been said, I think she would refer, and I think she is okay now to proceed. I think the court's probably aware that she does have some mental issues. And this is a reset from yesterday when, unfortunately, I had another court that I could not get away from. We have a motion to reduce bond. Would you?
All right, who's the prosecutor that will be on this?
Judge, I'm sorry, I do not know that answer.
All right, let me see if it's criminal trial division or family violence.
It is criminal trial division.
All right, let me see who is available. Marcus Sanders, are you able to confer with Eddie Bravenik on Lindsay Phillips, or if there is someone else? Hunter seems to be stuck in breakout room number 13.
Yes, Judge, I can.
All right, so courtroom, if you go to breakout room number 4, please.
Yes, Judge.
Thank you.
Thanks, Judge.
You're welcome. Jonathan Watkins?
Yes, ma'am.
Yes, on Marino.
Yes, Judge.
So what are we, Mr. Marino, were you able to confer on a trial date?
I need to get a date, Judge. I was just waiting for Norma and Joe Gray. I did
I'm sorry, go ahead.
And after that, Judge, I was going to ask Norma to put me in a breakout room with Mr. Moreno so I could just talk to him briefly.
All right, so Joe Ray, if you'll go to breakout room number 8, please. And Norman Ferguson, if you'll go to 8. And Jonathan Watkins, were you previously assigned to a breakout room? Number 1. All right, if you go to 8, they'll confer with you on a date.
Thank you, Judge.
You're welcome. And everyone, just give us a moment. Hi, and I've signed the paperwork on Jackson, at least everything that's been sent to me.
Okay, let me see you come back to me.
All right, thanks. All right, Norma, can you let them know that L27 can go back?
Yes, ma'am.
Have a great rest of your week, Ms. Hutchins. Frankie Sandoval on Aaron Pouch. And I believe he's on the phone conferring. Joe Ray, do you have a date with Mr. Watkins? You're on mute. Everybody's muting today, Brenna.
On September 30th, Judge.
Judge, which inmate did you say was ready to go? You said L27.
And Hutchins.
Yeah.
Mm-hmm.
All right, Brenna, you ready? Court is calling 2020 CR 0666, 2020 CR 7894, 2020 CR 1318, and 2021 CR 2280, State of Texas versus Michael Marino. Can I have parties announced for the record for the state?
Joey Garcia.
For the defense?
Jonathan Watkins for Mr. Moreno, Your Honor.
All right, and are you Michael Marino? Brenda, it's like we're starting over from scratch. Norma, can you have someone go help Mr. Marino to 1, turn back on his video, 2, to turn on his sound? Thank you.
Judge, it's Eddie Brovanek. May I jump in while we have a short break?
Yes.
So Ms. Phillips is interested in going living with a father who's willing to take her. Unfortunately, the father is not available today, and so I'll need to get him to be able to be in front of the court. I talked with Marcus, who agrees with that assessment. Is there a way I could reset this case on the bond to Monday or Tuesday of next week to have him present?
Norma, can you recall Ms. Phillips for next week?
20th day of November 2013.
Yes, ma'am. What day do you want?
Defense is requesting either Monday or Wednesday.
I can do Wednesday.
That's exactly what they just used the drug case instead of the robbery.
All right, so we'll be back on Wednesday with your client.
Pretty much in line. Okay, but I got one question up here.
And that will be August 4th.
Whatever. Should I be signing it if they haven't put the agreement to dismiss the other?
I don't know if you know this. I understand.
Judge, can she be excused?
Yes, Mr. Brovinick, do you still need to speak with Ms. Phillips or no? Eddie Brovinick, do you still?
Judge, I'm sorry. I was over in the corner. I don't need to speak with her. I'll call her dad if we could just reset it for Wednesday.
All right, Norma, you can let them know that Ms. Phillips can go back. She's L27.
Thank you.
Thanks, Judge.
You're welcome. All right, Mr. Marino. Whenever I need to talk to you, you need, oh, Brenda, I don't know what he keeps touching. I really don't. Jonathan Watkins, why does your client keep disabling his video? Can somebody tell that to me?
I'm not touching anything, ma'am. It's doing it on its own. They told me to press the soundbar, and that's what I did, and it disappears.
All right.
And yes,
Brenda,
Mr.
today is Tuesday, not Monday. Everybody put some patience in your pocket. All right. We're proceeding with this hearing by video. Any objection from the state?
I'm looking for
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Mr. Moreno, do you have any objection to this hearing taking place by video?
No, Your Honor.
All right, state, defense, have you received all the discovery in each of these cases?
Yes, Judge.
All right, it's the court's understanding that the defense is rejecting these offers. Is that correct, Mr. Marino? Are you rejecting the state's offer that has been tendered?
Yes, ma'am.
Are you requesting a jury trial?
Yes, ma'am.
All right, my understanding is that both parties had a chance to confer on a jury trial date. Is that correct, state and defense?
Yes, Judge.
Yes, Your Honor.
So the jury trial date that has been agreed on is September 30th, 2021 at 9 a.m. State, any objections to that jury trial date?
Okay.
No objections.
Defense, any objection to that jury trial date?
There's no objection, Your Honor.
All right, Mr. Marino, any objection to that being the jury trial date?
No, Your Honor.
All right, then state, in each of these cases, I'm going to need your acknowledgement of discovery.
I haven't put them on yet.
Okay.
Oh my gosh.
I'm from the chapel.
Okay, somebody is acting as though it's Monday, Brenda. They're acting like it's Monday and it's like 5 p.m. and their day should have been done. So we're going to do acknowledgement of discovery. I'm going to need that done by August 13th. State, are you able to get the acknowledgement of discovery done by August 13th in these cases?
Yes, Judge, I will.
All right, and the court does recognize that one of these cases is a possession less than a gram case. So criminal trial division on that case, you'll need to have the acknowledgement of discovery by August 13th. And state, if you will let the defense know which case you intend to proceed on at a suitable time.
Yes, Judge.
Okay. But defense, you'll need to be ready for all the cases for jury trial on September 30th. Do you understand?
Yes, ma'am.
All right, then, Mr. Michael Marino, the court will not accept any plea bargain agreements after today. So what that means is that if you decide to enter a plea, the court will only accept a plea that is open to the court. Do you understand?
Yes, ma'am.
Your trial will be scheduled on September 30th at 9 a.m. You'll be brought over to the courthouse. If you're at the Bexar County Jail, you will be brought over to the courthouse dressed for trial. So when is your trial date, Mr. Marino?
On the 30th of September.
All right, and which court?
187.
All right, and the 187 District Court is located at 300 De La Rosa. If you are released or make bond from the Bexar County Jail, you'll need to be present. Do you understand?
Yes, ma'am.
All right, defense, unless there's anything else, we'll close the hearing.
Just that the only other thing I have, Judge, regarding his cases is that we do intend on filing another request to have a bond set on the 2 cases he's been remanded on, and we'll e-file that.
Okay. All right, thank you. Norma, can you let them know that 16A can go back, please?
Judge, is there any way I could talk to him real quick?
Yes.
Yes, ma'am.
Really briefly.
All right, defense wants to talk to him briefly, Norma.
Okay, just make sure he comes back to the main room, Jonathan.
Yes, ma'am.
Thank you.
All right, I'll send you to number 6, and Mr. Watkins, you can talk to your client as long as you need.
Thank you
So
for
both of
your
you can-
time, Judge.
Oh, you're welcome. So both of you guys can go to number 6, please.
Thank you, Your Honor.
You're welcome. All right, everyone, just give me a moment, please. All right, Rick Crow.
Yes, ma'am.
All right, Mr. Crow, are you driving?
No, ma'am, I pulled over. I was actually going to my office. I was on, since we were stuck, I needed to get some work done at my office. So I was heading over there while I was waiting.
All right, so what is happening with your client?
I spoke with the prosecutor, and she wanted to take a look at a little more evidence and wanted a reset date. It looks like we might be able to get this resolved after she reviews some of the evidence.
Okay, did she give you an idea of how much time she needs?
I believe we talked about 30 days.
All right, Norma.
But it can probably get resolved a lot sooner if, based upon my conversation with her, she just said that she just wanted to do a little review and asked for 30 days.
Yeah, Judge, we might get it resolved before then, but if it could just get a standard reset, please.
All right, Norma, can you recall Mr. Damon Mueller for 30 days, please?
The 24th, Judge.
All right, we'll see you back on August 24th.
Very good. Thanks, Judge. Want to be excused?
Yes. Good. Top of the morning to you. You're on mute, Bob.
Sorry, top of the morning to you, Judge. How are you?
Oh, great. Happy Tuesday. It's always great to have you here. You're always in a happy mood. I like it. Who do you have?
Oh, I have Danielle Lara, Lara. It should be a plea. I think we've done the paperwork, and I sent her this Zoom link last night, so I hope she's here. I apologize. I was in a sentencing in a federal.
No problem. What I'm going to do, because I don't have any paperwork, was paperwork sent to you?
I've slept since then, but I certainly thought we'd done all the paperwork. I definitely remember recently signing a certificate, I think on recovery. So I thought that was.
So what I'm going to do is I am going to send you to a breakout room. I'll send you to breakout room number 2, and a prosecutor will meet you there.
Thank you, Judge. Thank you.
You're welcome. All right, are we ready? Frankie Sandoval, are you ready on Mr. Pouch?
Good morning, Judge. Yes, Your Honor, at the court's convenience. For the court's information, we do have one likeness, and I wanted to confirm that the court has in its file the 2 character letters sent in on behalf.
So
Yes, I do have the character letters.
have the witnesses and they show up, or they.
I have one from Jeff Wilkerson,
And so.
Yes, Your Honor.
and then the other one is from Janet, and I can't read her last name, Mern, I believe.
And that's part of the.
Men,
Yes.
Is they understand there's a risk.
and we
Okay.
have one live, Your Honor, Miss Michelle Plow.
Okay, so who are the, who's the prosecutor on this one?
So, you know, I guess that's a pretty.
Somebody from,
I can do it, Judge.
all right, thank you.
Mr. Pouch?
I did not know why. When I type up, do you know, people are not popping up when I type their name in? Something's happened to the system. So let me see if I can scroll through and find the courtroom. Yes. Yeah, see, look. There's Frankie right there. It won't pop up. And even when I put Brenna's name in, oh, it finally popped up. So, yeah. Yeah, it's a Monday. All right, the court is calling 2020 CR 0160, State of Texas versus Aaron Pouch. They have parties announced for the record for the state,
Martin.
for the defense.
Morning, Frankie Sandoval on behalf of Mr. Aaron Pouch.
All right, and Mr. Pouch is in the courtroom. We're proceeding with sentencing by video. The court will note for the record that the plea was entered by video on June 21st. I'm sorry, June 3rd. Any objections to us proceeding by video, state?
No objection.
Defense.
On behalf of Mr. Pouch, no, Your Honor.
And the court will note for record that the defendant is in the courtroom. According to the plea bargaining agreement, punishment is to be assessed at a cap of 6 years in the prison. The state is silent. Have both parties had a chance to review the PSI report, state?
Yes, we have.
Defense.
Yes, Judge.
Any objections to the PSI report, state?
No objection.
Defense.
Your Honor, no objections. We just appreciate the court giving us this opportunity to flesh out some things between the lines.
All right, the state is silent then. Defense. You may begin.
Your Honor, good morning. I'm here on behalf of Mr. Pouch. We are respectfully requesting, Your Honor, to please place him on community supervision. He currently lives up in Kerrville. And if possible, we would appreciate the opportunity for him to, and I'm going to use the term continue his community supervision, because as the court is well aware, Mr. Pouch is currently on community supervision on a controlled substance matter. And as the court is well aware, we'll be approving a positive through a negative here. There being no adverse history being presented to the court with respect to his current community supervision demonstrates a positive, I would assert, as to his ability to complete whatever conditions, terms, and especially restrictions the court places on him with respect to community supervision in this current matter, Your Honor. And I say restrictions because, of course, there is reason for concern on the court's part with respect to the complainant in this case and her feelings, her needs, her desires. I appreciate and can understand, as does Mr. Pouch, the totality of the circumstances the state took in coming about with its offer of a silent probation, given Mr. Pouch's history, which to be liberal, we can say is checkered. But as the court will see, most of it is from years, if not decades in the past. I would also ask the court to view Mr. Pouch's history and take it into consideration since the time of his release from the Bexar County Adult Detention Center. Since that time, he's been living up in Kerrville and has had no issues whatsoever, staying away, maintaining distance, not having any contact whatsoever with the complainant in this matter. Mr. Pouch is fully aware of any negative impact that would befall him prior to his plea and now the sentencing, should anything adverse had occurred between him and the complainant. And that remains the fact, Your Honor, should this honorable court place him on probation. That same proverbial, if I may use the term, axe hangs over his head with respect to staying away, not contacting, not having any sort of association with Ms. Turner. Mr. Pouch is well aware of that and will abide by whatever conditions this court places. The relationship, as the court can see from the reports, initial reports, to the pre-sentence investigation to Ms. Turner's statement, has been tumultuous, to say the least. We are here and, Your Honor, taking responsibility for this matter. But as the court is also aware, there are always two sides to every situation. And Mr. Pouch's version of this matter is just to separate himself from the situation, remove himself from it as he's done and as he will continue to do if this court permits him the opportunity and the grace, the good grace, to be placed on community supervision, Judge. The TAP evaluation is where we find ourselves, and any conditions the court places there, Mr. Pouch is willing to abide by, as has been demonstrated by his current community supervision on the controlled substance case that he's currently on. Similar or additional restrictions can be placed by this court to ensure Mr. Pouch's continued abidance by whatever's required of him, Your Honor. And for Mr. I apologize to Mr. Martin. I don't believe I sent him the two reference letters for Mr. Martin's information. What they were, Mr. Martin, were just letters of customers from Mr. Pouch, and saying that they've had honorable dealings with him in his role as a mechanic. Mr. Pouch, in this 6 months, Your Honor, and he's available to answer any direct questions from either the court or Mr. Martin, has started a small traveling mechanic business there in Kerrville. As in one of the letters from Mr. Wilkerson, Mr. Martin, folks at the local O'Reilly auto shop refer customers to Mr. Pouch as someone who can help them with situations. So he's gained a good reputation there in the community of Kerrville and Kerr County as a whole. And he's getting his life back on track, Your Honor. I don't mean to any offense to Mr. Pouch today, as I'm in the same situation. We're sort of on the tail end now of the curve of our lifespan and our age. And Mr. Pouch is looking, mainly by separating himself by the negative situations that he found himself in Bexar County, to enjoying whatever grace the Lord gives us with respect to the rest of our life, Judge. If I may, I do have one witness I'd like to call, Your Honor, with the court's permission, and that would be Michelle Plow.
I'm sorry, who?
Miss Michelle Plow.
Can you spell the last name?
Yes, sir. Yes, ma'am. I'm sorry, Judge. Ploch.
All right, if she could come forward, if she's in the courtroom, please. All right, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, if you can lower your hand, please make sure that you speak up. If you could state your name and spell it for the record, please.
My name is Michelle Plow, Ploch.
All right, defense.
Thank you, Your Honor. Ms. Plow, good morning. If you could please inform Judge Boyd, how long have you known Mr. Pouch?
A little over 6 months.
And how did you come to know Mr. Pouch, and what is your relationship with him?
Well, a friend of ours, mutual friend, had just gotten picked up from jail and sent a text out asking anybody who would put someone up for the night. I responded and I asked exactly what he did and is he dangerous? You know, normal things you would ask. And he said no. So I said, okay, he can stay. And what turned into one night has now been over 6 months. And it's been a pleasure to get to know him. He's just so
Thank you. As a tenant in your home, Ms. Plow, have you become aware or were you made aware of Mr. Pouch's history?
Yes. Once we slowly started talking and getting to know each other, he explained his history to me.
And during these 6 months, is it safe to say you've had the opportunity to see him in a stressful or difficult situation?
Oh, yes, many times.
And when you've witnessed him in these situations, have you ever been concerned or fear of your safety, or has it reached a level where you've had any question as to allowing him to remain a tenant?
Oh, no, he has never, ever reached that level. Usually when he gets frustrated is he goes to work on a job and it is never the simple picture of what he has to do. It ends up being more invasive and it's never goes right.
Now, there in Kerrville, perhaps even more so, as with the rest of the state of Texas, in February, we suffered an adverse weather event. Could you let the court know how Mr. Pouch reacted to that and what assistance he provided you?
Oh my gosh, if it wasn't for him, I'd probably be dead. I live alone, I'm disabled. Oh, Aaron lives there, but he got me through the snow we had no power. I live in a mobile home, no electricity, and nothing as everywhere else. He got me to a place, a friend of ours, Jeremy, we stayed one night there. And then we went to my son who lives in Ingram and we stayed one night there. We would have stayed more, but he lives in a small RV and it was just too cramped. And then the rest of the week we stayed at his friend's, I forget her name. She works for a man who has cabins. So she let us stay in her cabin, which had full electricity, everything cable. We stayed in there for the rest of the week until things got better. He made sure I was safe. Because I woke up, I was so cold and shaking, and he got me through it all.
Now, in the court's ultimate wisdom, should the court place Mr. Pouch on community supervision, you realize it will be his sole responsibility to adhere to all the conditions. But my question to you is, would you support him in whatever's necessary, whatever conditions the court places on him, restrictions, should the court in its wisdom place him on probation?
Yes, I support him 100%, as do his customers. He has built a heck of a customer support. They adore him, they love him. One lady who didn't write, she owns a pet rescue. We overheard her when she didn't turn her phone off, saying, "It's so nice to have a mobile mechanic come to you, to our house. He is the greatest." It was really nice to hear.
Thank you so much, Ms. Plow. No further questions, Your Honor.
All right, state.
No question.
All right, defense, any other witnesses?
No other witnesses, Your Honor. I will once again reiterate that Mr. Pouch accepts full responsibility by entering his plea. It has demonstrated to the court and to the state and to himself, most importantly, his desire to right his path. And he remains available should the court have any specific inquiry you would like to make, or Mr. Martin.
All right, I have a question. Defense, and I don't know if you want to call your witness. I mean, I don't know if you want to call Mr. Pouch as a witness, but I'm reviewing the PSI report, and here it says guilt minimized.
Your Honor, if I may address that, if it's not sufficient, I'd be happy to call Mr. Pouch.
Yes.
He's the type of client I've enjoyed having. Your Honor, as I mentioned, this relationship was a tumultuous relationship, and it is one where we don't like to view things negatively in the past and just went forward. And I believe that's Mr. Pouch. What may come across as minimization is just Mr. Pouch's desire to put the past in the past and to create a bright, wonderful future for himself.
All right, and then the other question the court has, what is this information pending? Does the state of probation know? Does this mean that it says information pending, but does that mean you all are not going to have that information? It's not coming? Does anyone know?
I do not, Your Honor, and given the time frame involved with those, I'll be honest. I was going to put these sleeping puppies to lay.
Okay, well, because my concern is, I mean, self-mutilation by a prisoner, I'm assuming that was your client, and it says information pending. Aggravated battery with dangerous weapon, information pending. Simple battery, information pending. Illegal carrying of weapons, information pending. Municipal purposes, I don't even know what that is. Does anyone know what municipal purposes is? Is that even a charge?
Your Honor, my only response there is it takes me back several decades back to law school, where this applies everywhere across the country except for Louisiana.
All right, and then taking contraband to or from a penal institution, information pending. So do we know probation, is that information forthcoming?
I'm reaching out to them right now, Judge.
All right, thank you. Because that the court would need to know that in order to make an informed decision. And it seems that we have a lot of cases here. A majority of them, again, are information pending. But I would like to know what is going on with those cases in order to make an informed decision on whether or not I should grant him probation or not. I see we have cases from 2013 that are assault cases. We have one that is from 1997. That's an assault case. It appears that on those cases, he did time. But we have a theft here from Jefferson County, where I think he did prison because it states 6 years confinement and he was paroled. He had another assault, which I'm not going to take, in consideration. It says rejected without a pretrial diversion. Driving while license suspended, driving while license invalid, driving while intoxicated, burglary of a building, confinement 7 years. Then we have another assault. I'm sorry, that's just the same assault bodily injury from 2013. Then we have manufacturing, delivery of a controlled substance. He was given deferred. Then we have a possession case. He was convicted and confined. So these are concerns for the court. He has 25 misdemeanor arrests, 12 felony arrests, 4 felony convictions, 12 misdemeanor convictions. He's been given supervision 3 times, revocation on a supervision. It's like at some point, how long does it take someone to get their life in order to stop committing crimes?
And thank you, Your Honor. We appreciate that, which is why Mr. Pouch and I presented himself before this court, fully aware of his background and his history. And you're absolutely correct. One of the factors we utilize in trying to assess what may occur in the future is the past. And that's also why we wanted to stress the past with respect to the time since his release from the Bear jail and his current community supervision and, for lack of a better term, success on his current community supervision, because we believe that past ought to be taken into account and viewed in the totality of his spirited youth with respect to Mr. Pouch being able to successfully complete his community supervision. I raised these same concerns with Mr. Pouch, and again, it for lack of a better term, he's tired, Judge. He's tired, and he's enjoying his life in Kerrville. He's enjoying his work, and enjoying the possibility of being able to continue his life away from any negative attributes, knowing full well that that axe hangs over his head should he deviate in any way.
All right, and states you were previously opposed to the defendant's application. Is there a reason why you changed from opposed to silent? All right, and Rebecca, you said that you're looking to see about those pending information.
Yeah, the PSI officer is looking into it right now.
All right, so Mr. Sandoval, we're going to take a brief recess. Mr. Pouch, you can take a seat. We're going to take a brief reset so I can figure out what's going on with the pending information, and the state can let me know why they changed from opposed to silent.
Thank you, Your Honor.
You're welcome. So I'm going to remove spotlights. And Mr. Sandoval, if you know why the state went, because I'm not sure which prosecutor you negotiated with, I can send you to a breakout room with the state and maybe you can tell them if you know the reason behind that.
Besides my lawyering, Judge?
I'm sure.
I think he just beat us in the submission.
Okay, so what I'll do is Frankie Sandoval, I'm going to send you to breakout room number 4, and the prosecutor will meet you there. David Woodard, if you can show your video, please. And who is the prosecutor on, sorry. Who's the prosecutor on Jaquin Jackson?
It's David Martin.
Ah, okay.
So
Thank you,
don't let
David
him go.
Martin.
Judge, can I see in a breakout room real quick?
Okay, can you just give me 1 second, Rebecca, and let me do this
Yes, ma'am.
real quick, and then I'll come see you in a breakout room. All right, the court is calling 2020 CR 5695, State of Texas versus Jaquin Ray Jackson. Can I have parties announced for the record for the state,
David Martin.
for the defense?
David Andre Woodard.
And are you Mr. Jackson? Oh, just press the space bar and hold it down. It's the longest bar on the keyboard.
Yes, ma'am. I'm sorry, it wasn't locked in. Yes, ma'am. I'm
That's
Jackson
okay.
Jackson.
All right, we're proceeding by video. Any objection from the state?
No objection.
Any objections from the defense?
No, Your Honor.
All right, everyone, just give me 1 moment, please. Mr. Jackson, I'm going to show you what's entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am, I did.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Defense, I'm showing you the discovery acknowledgement. Have you received all of the discovery in this case and did you review it with your client?
Yes, Your Honor, I did.
Court will find that the state is in compliance with discovery. Mr. Jackson, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, we are.
All right. Are you proceeding with the repeat offender enhancement allegation?
Yes.
So this would be second degree, correct?
Yes.
All right. Any objections to the court changing the degree to second degree in the paperwork?
No, Your Honor.
All right, Mr. Jackson, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand what you're charged with is felon in possession of a firearm? That's a third degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. But because the state is proceeding as a repeater, then your range of punishment will be anywhere from 2 to 20 years in prison and up to a $10,000 fine. Do you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am, I do.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Judge, and he was at the time.
All right, off the record for a moment. Ms. Calderaro, if you'll go to breakout room number 5, and if someone from family violence can meet her in number 5. Back on the record, Mr. Jackson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am, most definitely.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am, I did.
According to the plea bargain agreement, you are to agree that you've previously been convicted of one or more felonies for enhancement. Punishment is to be assessed at 3 years in the prison. There are no applications for community supervision or deferred adjudication. You will forfeit weapons seized, a Glock 21 with serial number BB as in boy E049 and Stag Arms Stag 15 serial number Y425982 and all firearm magazines seized. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is, Judge. There's also some additions on cases that are going to be dismissed that were not included on the plea paperwork. I believe they were accidentally left off at some point.
All right, and these are cases that will be taken in consideration?
Yes, that's correct, Judge.
Any objections to the court inserting that in your plea bargain agreement?
No, Your Honor. Yeah, no, they were in there, but I guess when I added the attachments, some things got booted off. But one of them is cause number 2020 CR 5449. The other one is grand jury number 735157.
And are those the complete cases to be taken in consideration, defense, state?
Yes. I believe so, Judge. It should have been an aggravated assault, which I believe was an indicted case, and then the grand jury case should have been a drug case. Yes.
All right, then did you understand that to be the entirety of the plea bargain agreement, Mr. Jackson?
Yes, ma'am, I do.
State, is that the entirety of the plea bargain agreement?
Yes.
Defense, is that the entirety of the plea bargain agreement?
It is, Judge. There's one thing that I believe is going to be added also on the record, and I know it's in the court's discretion, but that this case is running concurrently, or will run concurrently with any parole violation that he receives. I know it's ultimately up to parole, but we would like to know if the court can place that on the record, that this case, in the event that he's revoked on the parole case, that it would run concurrently.
Yes. All right. Next, I'm going to show you, Mr. Jackson, what's entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
Yes.
I'm sorry, what?
No contest.
State, any evidence to support the defendant's no contest plea?
The law offer states one with the attachment.
Any objections?
No objections, Judge.
Mr. Jackson, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review this document with your attorney? Did you
Yes,
understand
ma'am.
it, and did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, the state would be presenting evidence in the form of witnesses' statements, police reports, and judgments, but most importantly, there would be no live testimony. Did you understand?
Yes, ma'am, I do.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Mr. Jackson, to the enhancement paragraph as stated in the indictment, how do you plead? True or not true?
True.
All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty of felon in possession of a firearm based upon your plea of true to the enhancement in states exhibits 1 and attachments. The court will find the enhancement true. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, we're just asking the court to follow the plea bargain.
All right, then the court will sentence you to 3 years in the prison. Take in consideration 2020 CR 5449, grand jury number 735157. Defendant forfeits all firearm magazines seized. Block 21 with serial number VBE049. Stag Arms 15 with serial number Y425982. Credit for any time served. This is run concurrent. Do you have a parole number, Mr. Woodard?
Judge, I had the cause number. I sent it to David Martin. I don't have it with me. It should be on the email that I sent to him.
It's 2013 CR 4539.
All right, this will run concurrent with parole case number 2013 CR 4539. Is there anything else from either side with regards to sentencing?
Not from
Not,
this.
All right, Mr. Jackson, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it?
Yes, ma'am, I did.
Because this is a plea bargain agreement, because I followed your plea bargain
Yes, ma'am, I
agreement.
did.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am, I do.
And I think it goes without saying, this is a felony conviction for felony in possession of a firearm. You're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Jackson, how old are you?
I'm 35.
All right, Mr. Jackson, here's the thing. Your life is going in the wrong direction. Either you're going to end up spending the rest of your life in and out of prison, which you'll end up being the grandfather at the prison. And when people want to know what the ropes are, they will say, ask Grandfather Jackson. That's what we called him. Or worst case scenario, you may end up getting killed, right? So you've got to decide if this is the way you want your life to go. If this is not the way you want your life to go, then you need to change what you're doing.
Yes, ma'am. Totally understand.
All right, good luck to you. Norma, can you let them know Jackson 16B can go back?
Yes, ma'am.
All right, Mr. Woodard, if you don't have anyone else with us, you're excused.
okay, thanks, Judge, and thanks, David.
You're welcome. And Rebecca, you wanted to see me in a breakout room?
Yes, ma'am.
All right, let me see if I can find you on the screen. If you'll go to breakout room number 3, I will meet you there.
And Judge, Michael Moreno's done, correct? I can send him back?
Yes, you can send him back.
And Judge, may I be excused? My client, as far as I can tell, has not shown up.
No, just give me one moment. We're going to go on the record with that, Ms. Bill. Just give me a second.
Sure.
16A, Michael Moreno can go back. Yeah, give me just a second. Gail, you're going to be moved into a breakout room with your client. Ms. Cortez, you're going to be moved to a breakout room.
You could both go to 9.
All right. Is there a prosecutor available on Kavonda Jackson who is not present?
Yes, Judge.
Hunter Morris is here, Judge.
Okay. I'll take whoever wants to go. We got a.
Hunter, you can have it. I don't think.
I'll do this. I've just been doing paperwork, Judge. I'm getting antsy.
Judge, would it be possible to just give me about a week for me to try to locate Kavonda Jackson?
No, the only reason why I say that is because we were here on July 13th and we had the same issue with her not showing.
Oh, I see. I don't believe I was the.
No, you were not. It was Wayne Young.
Oh, okay.
All right. The court is calling 2021 CR 5896A, State of Texas versus Kavonda Jackson. Can I have parties announced for the record, please, for the state?
Hunter Morris.
For the defense?
Phyllis Beal.
All right, we're proceeding by video. Any objection from the state?
None, Judge.
Any objection from the defense?
No, Your Honor.
This hearing was scheduled at 9 a.m. It's now 11:01 a.m. The case was previously set on July 13, 2020. Deputy Laura, is there a Kavonda Tanae Jackson in the courtroom?
No, Your Honor, she is not.
And has there been a Kavonda Tanae Jackson in the courtroom at all today?
No, Your Honor.
And for the record, she has not been on Zoom. Defense, have you had any contact with your client?
I have not, Your Honor.
All right, state.
Judge, they would ask the court to forfeit the bond and issue a warrant.
All right, that'll be granted. I'll remand your client without bond. Ms. Bill, if you're able to get in contact with your client and she presents herself, the court will reconsider.
Thank you, Your Honor. I will do my best to do that.
All right, thank you. Have a great rest of your day.
You too. Good to see
All right.
you. Okay.
You too. I feel like ages since I've seen you.
I know, but I really do appreciate the fact that you're doing the Zoom because it gets a little nerve wracking when you go down to some of the courts that are not.
All right. Thank you.
Thank you. Bye-bye.
Bye-bye.
Your Honor, this is Ms. Middleton.
Just one moment.
Yes, ma'am.
All right. So James Toshi, you're back on Miss Carvajal, Vargas Carvajal.
Yes, ma'am. I'm back, Judge. Oh.
And who was the prosecutor who was on this?
I've been dealing with Mr. Nisbet, Judge. So I don't know what to tell you. That's who I've been dealing with.
Yeah. Is there a felony prosecutor available?
Yes, Judge. What's going on?
This is her violation report
Oh, okay.
for Miss Brenda Carvajal Vargas. Okay. And we were not on the record on this before, correct, Brenda?
No, we weren't.
Okay. All right, Brenda, we're not going to go on the record. Miss Vargas Carvajal.
Yes, ma'am.
And let me see. So we're here again because you won't blow. I'm going to explain something to you right now. You're not going to be allowed to drive. I don't care who got your car, what's going on. You understand?
Yes, ma'am.
You're going to continue to use this device. If I get another report on this device, I want you to be aware of something. We're not having another hearing on this. I'm just gonna I'm just gonna issue a judge's warrant.
Yes, ma'am.
Then we can have the hearing for you at the Bear County Jail. Do you understand?
Yes, ma'am, I do.
Not coming back for this again. Do you understand?
Yes, ma'am.
And when you go to the Bear County Jail, because you're not following through on what your conditions are, then you'll have to make arrangements for somebody to take care of your children because they don't allow them at the Bear County Jail. You understand?
Yes, ma'am.
State, is there anything you would like to add? This is her 8th violation report. She keeps forgetting to blow into her device.
How many windows does she have, Judge?
Let me see. I think there are 4 windows. Do you want to increase?
Is she failing to blow into an interlock device, Judge, or is it a portable device?
It's a portable device. So she leaves her portable device because she's so busy, she forgets to take it with her.
Does the drug patch catch ethanol, Judge?
No.
Just if she's unable to make her windows, we could give her the option of antabuse.
Judge, one thing I do want to make you aware of, and I think she'd shared with me, she is currently with child. The only reason I bring that up is just she's not drinking. And so just so you know, in addition, just to abide with the court's orders, she is with child. And for that reason, especially, she's not drinking alcohol. But I understand any steps the court deems necessary.
All right, what I'm going to do is I'm going to increase the number of times she blows. State, are you okay with increasing her, the number of times she blows or gives samples?
Yes, Judge.
All right, so I'm gonna increase your number of blows by 2. Do not come back here, Miss Vargas. Do you understand?
Yes, ma'am.
Because the next time you come back here, your attorney will be hearing this case while you're at the Bear County Jail.
Yes, ma'am, I understand.
And Mr. Toshi, when is her next date?
Judge, I believe she has a court date next week set for a plea. I did not look it up.
Yes, August 2nd.
Yes, ma'am.
That's what I have on here. All right, we'll see you August 2nd. You need to be here on time. Do you understand?
Yes, ma'am.
All right, and Mr. Toshi, I see the plea bargain agreement. She can appear by Zoom.
Okay, thank you very much, Judge.
All right, if there's nothing else, you and your client are excused.
Okay, Judge, that was going to be my question for Mr. Tochi. Was I had thought maybe this particular case had an agreement already.
Yes, it does have an agreement for deferred, but I think there are some, is there immigration issues? What is the issue?
Yeah, that's it, Judge. An immigration issue emerged during the plea, and she's going to get that taken care of this week.
Send in the other people.
Okay.
All righty.
All right, thank you.
Thank you.
Thank you.
May I approach, Your Honor?
Yes.
Thank you, Judge. We have resolved Frankie Chacon. There's no need for a hearing.
Just give me one moment, Mr. Barrera.
Yes, ma'am.
Son in Middleton.
Yes, Your Honor. I'm here on Miss Peyton Vanderstein.
Yes.
They are going to dismiss the forgery, and she has not been indicted yet on the drug charge. It tested something that they didn't think it was, so we'll have to deal with that later. So we're just asking for a reset.
Well, I mean, if they're dismissing that, are they dismissing it today?
The forgery, they are, but she has a second charge for possession that they're not dismissing.
All right, let me see what page she is on. Oh, the drug case, that hasn't been indicted yet.
Yes, that's correct.
So that will be, we don't do pre-hearing settings unless it's requested.
No, ma'am.
So then your client is excused.
Thank you, Your Honor. Have a good one.
You're welcome. Vivian Casares.
Yes, Your Honor.
Yes.
On Miss Martinez, I conferred with the prosecutor, but I haven't had any contact with Miss Martinez. This is the first setting, Judge, she's had since she was arrested.
All right. Is anyone available for this hearing?
I am Judge.
Oh, yes, Norma.
Yeah, and you know what? The federal prosecutor wanted me to call him today.
I don't know if she may or may not be in the courtroom, Your Honor. I don't.
Yes.
All right. Is there a Marcy Martinez in the courtroom? No. All right. The court is calling 2021 CR 4966, State of Texas versus Marcy Rose Martinez. Could I have parties announced for the record for the state?
Meredith McIntyre for the state.
For the defense?
Vivian Caceres.
We're proceeding by video. Any objections from the state?
No, Your Honor.
Any objections from the defense?
No, Judge.
All right, Deputy Laura, has there been a Marcy Martinez in the courtroom at all today?
No, Your Honor, she has not.
And she has not been on the Zoom screen. Defense, have you had any contact with your client?
I have not, Your Honor.
All right, state.
State asked the court to forfeit the bond and issue a warrant.
All right, that'll be granted. Your client will be remanded without bond. If you're able to get in contact with your client, the court will reconsider.
Thank you, Judge.
All right, you're excused.
Thank you, Your Honor.
Just give me 1 second. All right, Bobby, let me see, Roy Barrera. Roy Barrera.
Yes, Judge.
Yes. And Gail Calrota, if you'll go to breakout room number 7, a prosecutor will meet you there. All right, on your client, Ms. Chacon, you said you all have I'm sorry, Mr. Chacon, you said you have an agreement?
Well, actually, we have the matter resolved. I filed a motion, Judge, to have the ignition interlock removed from my client's car. He had understood that you said he only had to have the interlock in his truck 6 more months beginning January 2021. So that would put us July 2021. However, Meredith was kind enough to get Loopy to actually pull your notes on the jacket, and those notes say that he's to have the interlock half the term of his supervision.
Yes.
So that doesn't expire till January 2022. So that resolves the issue in my client's mind. So
All right.
there's
Okay,
nothing
thank
for the
you.
court. Thank you.
All right,
Judge.
you're your client excused. Thank you for your patience.
Thank you, Judge. Thank you, Meredith.
Good day.
And may I approach, Your Honor?
Yes.
Judge, this is Bo Wood. My client is Daniel Lotta. She's in breakout number 2. We've signed the papers. I was wrong and Mr. Morris was correct that we had not signed. So she has signed the DA's papers, but we haven't done the court's admonishments yet. She's on 1%. She's at the doctor's office with her newborn baby. And I said, do you have a charger in your car? And she says, yes, I'm just waiting on the doctor and then I'll get in the car and start back up. So we may be losing her, but she's intent, as you and I are, to do this plea this morning. I just wanted you to know the problem she's having.
All right. I tell you what, if there's an issue where we drop her, we'll come back this afternoon. But if everyone just give me a moment, 1 second, Mr. Wood.
Thank you, Judge.
20th of August.
Just one second. Marcus or either Hunter, can I see you in a breakout room, please? Breakout room number 3. Norman, could I see you, please? All right, are the parties ready on Roger Villarreal?
Yes, Judge.
All right, and Mr. Wood, if you're.
Yes, Your Honor.
All right, and Mr. Wood, on your client, if we don't have the paperwork and you want her to come back this afternoon, we can have her come back this afternoon. What do you think? Oh, you're on mute, Mr. Wood.
Excuse me, Judge. Yeah, sure was. We've still got 40 minutes, but there is, if her phone dies, if she's still in the doctor's office. So I left her in the breakout room to kind of see where we are here. won't there be, after we do the DA's paperwork, won't there be court paperwork, you know, the admonishments?
Yes, there will be. So I'm going to send you to a breakout room, Bo, and I'll send, if you go back to number 2, and I'm going to send Norma Ferguson to number 2 with you.
Thank you.
All right, you're welcome. And I'm sorry, who's the prosecutor on Villarreal?
Hunter Morris, Judge.
All right. Oh, wow. I'm sorry, I have to set the photos up in a certain order because it makes it easy for Brenna and it makes it easy for me. There we are. All right, the court is calling 2020 CR 8435, State of Texas versus Roger Villarreal. Can I have parties announced for the record for the state?
Hunter Morris.
For the defense?
Eli Rico.
And are you Mr. Villarreal?
Yes, Your Honor.
We're proceeding by video. Any objections from the state?
None, Judge.
Any objections from the defense?
No objections, Your Honor.
Mr. Villarreal, I'm showing you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Showing you what's entitled application for deferred adjudication or community supervision. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor, I have.
Court will find that the state is in compliance with discovery. Mr. Villarreal, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor, I do.
State, are you proceeding on the indictment as presented?
Presenting on paragraph A, Judge, waiving paragraph B.
Any objections?
No objections, Your Honor.
Mr. Villarreal, I'm going to show you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand what you're charged with is theft of service, $30,000 to $150,000? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 10 years in the prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Villarreal, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, I am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that page with your attorney and did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, the state is proceeding on count 1, paragraph A, waiving paragraph B. There's a $1,500 fine to be probated. State recommends deferred adjudication. There's to be restitution of $21,650 to Antonio Reyes. There is restitution of $7,850 to Gustavo Mancilla, Mancilla. Restitution of $48,876 to Alexis Moon at, I guess, B&T Glass. Restitution of $281 to Dan Cadena. And restitution to the Bexar County check section for DA fees related to returned or insufficient checks. Did you understand that to be the plea bargain agreement, Mr. Villarreal?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
It is, Judge.
Next, I'm going to show you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 5 years. There be a TAP evaluation, 150 hours community service restitution, the MRT, and theft courses, the level 2 course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Did you understand?
Yes, Your Honor.
Then to the offenses charged in indictment, how do you plead? Guilty, not guilty, or no contest?
There'd be no contest, ma'am.
State any evidence to support the defendant's plea?
Stay out for State's Exhibit 1 of attachments, Judge.
Any objections?
No objections, Your Honor.
Mr. Villarreal, I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
All right, and State, these are the all of the complainants that are owed restitution are the complainants that's listed in the plea bargain agreement.
Judge, Oscar Rios is not listed in the agreement. I conferred with the check section this morning, and those amounts have been verified, paid back. So Oscar Rios was excluded from the restitution, but included in the indictment.
All right. Mr. Villarreal, are you employed?
Yes, Your Honor.
And what do you do?
I'm a contractor. Like a general contractor.
So here's the court's question. Obviously, I have in the state's exhibits a lot of unpaid bills where people are doing work for him and he's giving them hot checks. So with his current occupation, which I'm assuming is the same occupation he has when he was writing bad checks or checks with insufficient funds, how are we going to monitor that this isn't happening again?
Well, Your Honor, I think that he understands that if he continues on this path, he's going to prison. This is the biggest deterrent that we have at this point. You know, I've made it very clear to him that he's looking at 2 to 10 if he continues to on this path, and he's made it very clear. And I think he's made a big effort in trying to repay these folks back. It was a time that he ran into some financial difficulties and obviously made some very stupid mistakes. But at this point, I think, you know, he understands the ramifications if he continues on this path.
All right, State, do you have any objection to his place of employment?
At this point, Judge, no. If we have any subsequent issues, then that can be addressed with probation, and an MTR can be filed. I would just note for this court that there was a good faith payment made yesterday of $5,000. That is in addition to the payment made to Oscar Rios.
All right, so this is what the court will do. The court will sentence him to a $1,500 fine. That will be probated. 5 years deferred adjudication. Restitution as follows. $21,650 to Antonio Reyes. $7,850 to Gustavo Mansilla. $48,876 to Alexis Moon at B&T Glass. $280 to Dan Cadena. And restitution to the Bexar County check section for DA fees. Proof of employment within 15 days. No employment as a home health care provider or supervision of minors. 150 hours of community service restitution, or he can pay $7.25 per hour to the San Antonio Food Bank. The MRT, theft course, level 2 course, regular UAs, or he can patch. Regular Zoom reporting. If something happens and you can't report in person, you need to report. I'm sorry, if something happens, you can't report by Zoom, then you need to report in person. Random field visit 1 time per month. Mr. Villarreal, do you have any drug or alcohol problems?
No, Your Honor.
If you're drug tested today, what will the results be?
Should be clear. I haven't drank anything, so.
Any marijuana or anything like that?
No, Your Honor.
All right, Rebecca, is there anything else that he needs?
No, ma'am.
Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we're gonna close the record. I'm gonna send you to breakout room number 2. Mr. Valeriano, part of running a business is paying people what you owe them.
Yes, ma'am.
So
I
they want you to do the MRT course. My understanding, the MRT course is trying to situate you where you know right from wrong, to build character. So I'm telling you right now, don't write another hot check. It's better to pick up the phone and call people and say, I don't have the money this week. This is what's going on. 9 times out of 10, people just want to know that you're not ducking and dodging them, okay?
Yes, ma'am.
All right, so I'm sending you to breakout room number 2. If you go to number 2, probation will meet you there and go over conditions.
Yes, ma'am.
Gail Calderoa.
May I be excused, Your Honor?
Yes.
Thank you, Your Honor.
What is happening with your client?
My client wants to talk to her family about the offer that has been made by the, can you hear me, Judge?
Yes, I can hear you.
Okay, she wants to talk to her family before and to consider the offer that has been made by the.
All right, I need you to go to breakout room number 9 and have her come out to the main room, please.
Okay, I will.
Thank you. Mr. Orta, who are you here for?
It's Dad sent me a text yesterday on the Robles, Christopher Robles. I think it was an add-on yesterday.
Yeah, it's a violation report, and your client is Mr. Christopher Robles in the courtroom. Brenda, is he in the courtroom?
No.
All right. He's already remanded without bond for not showing on.
Judge, I talked to him yesterday, but it's a conflict since the beginning. I'm gonna have to file a notice of what do you call it? A motion to withdraw, because he's. I told him about the setting last time. He had to be in person, and he asked me why. I told him it was a court order. The judge was asking him to do that. He didn't show up, and last night, there's a conflict.
Yes.
There's a conflict. The only bad thing is that I made the bond, and he hasn't come up with anything on the bond either.
Okay, so here's the thing. On Christopher Robles, on the NIMAG number, that's 584325, I'm going to issue a judge's warrant and remand him without bond.
Thank you, Judge.
Thank you.
May we be excused?
Yes.
I be excused.
Yes.
Thank you.
All right, anyone else ready? Bobby Gebbia.
May I be placed into a breakout room with Meredith, please?
All right, I'll send you to breakout room number 3. All right, and then we need to have Mr. Sandoval removed from number 4. Let me just go grab Mr. Sandoval from number 4. All right, Mr. Pouch.
Yes, ma'am.
Yes, you're gonna need to come back to court at 2 p.m., okay?
Yes, ma'am.
All right, we'll see you back then. Gail Calderola, I think she's still in the breakout room with her client. Okay.
Judge, we have a deal on Brewer. And I'm gonna chat it to Norma. I'm just trying to get the emails and stuff.
Okay, thank you.
Judge, I just sent you a chat.
Okay. All right, Mr. Jesus Cole, where are you? Is there a reason he's not on Zoom, Norma?
He wasn't able to contact him, Judge. She just was too, whatever I sent you, was too ill.
Okay. Norma, recall this in 30 days.
Okay. Read the 24th, Judge.
Okay. And have you been able to get in touch with David Cuellar
David?
and James Myrick? James Myrick has Paul Hernandez. And David Cuellar has Jose II, who's in custody.
Let me try to get hold of him right now, Judge.
All right, and Arthur Washington. Where's your client, DeAndre Job?
Judge, he's been on Zoom this morning. He was I saw him in a yellow kind of shirt.
Okay, all right, I see him here. Let me see, this is Criminal Trial Division. I'll send you to a breakout room to confer with the state.
If I may, Judge?
Yes.
We spoke with the state yesterday. Mr. Job submitted a pretrial intervention package. I was told that that would be conferred, and we've accepted that. We submitted that about 3 weeks ago, maybe a month ago.
Okay. Then just 1 second. Norma, on DeAndre Job, they're gonna need a PTD update.
Okay. But you want me to call in and see where they're at on that?
Yes, please.
Okay.
All right, we're gonna find out where we are in the process, Mr. Washington, and then we'll give you a new date.
I'll stay on mute, wait for the court.
Thank you. Okay, Brenna, I'm about to do a spoiler. I know people are going to be upset with me, but you know what? You should watch things when they happen, right? U.S. women's gymnastic team, silver medal, people. Simone Biles is like, I'm out. I have to handle my mental health.
Email is James Brewer.
Wait, did that really happen, Judge?
Yes, I'm only speaking truth there. Yeah, yeah. The women won
He
silver.
also talked about having feeling the pressure before.
Yeah. People put too much pressure on her. See, America, you expect people to be great 100% the time and be on it. There's a lot of pressure. You know, Brenda, you know what stopped me from doing gymnastics? I walked up to that balance beam and I'm like, this is crazy. I'm like, can we do it where I'm not on the balance beam? Can I still do this? They're like, no, that's one of the rotations. I'm like, bye. Good luck with that. Because what the teacher made us do, Brenna, they made us, you know, I don't deal well with heights. They make you stand on it and just walk it. Yep. And I was like, yeah, I'm pretty much done. I can't even, if you could have saw me holding on to that beam because I thought I was going to fall, I don't think people realize how high that beam is. And then you want people to do cartwheels on it. And no, that's very hard. And the guy's just complaining about their old pommel horse.
I don't know why.
Yeah. You know, there's a video of a guy. He's probably like in his mid-20s. So he does these videos where he goes to the girls' gymnastics gyms with their coach and tries to do what they do. It's pitiful. It's just pitiful. So anybody else want to know what else happened in the Olympics? Did I spoil it for everybody?
The Philippines got their very first ever gold medal. That was exciting.
Yes, isn't, you know, the Olympics is always, I'm always like, yay, it's a lot of fun. But I will tell you this, the men, I love the rings because to be a gymnast on the rings, that takes strength. Plus they want you to make those rings for you to hold still on the rings without the rings moving. That's hard. There was a guy who would do this thing on the rings called the Iron Cross, where you have to stretch your arms out, hold the rings, Brenda, without moving them. And he was so good at it. He would stretch his arms out, hold the rings, and then bow to people. And people were like, now you're just showing off. Is that what Olympics is really about, showing off?
Okay, Judge.
Yes.
Mr. Quire wants, he said he's in the 144, about to do a plea. He's asking, do you want him to come back at 1:30?
Told him to come back at 2.
2, okay. And then,
on the Job pretrial diversion.
2, give me 1 second, Judge.
Okay.
Okay, the one on Job, they said they received the application at 11 today, but it was sent back to the attorney because it was incomplete.
All right, so Mr. Washington, his
application has not been received. So there's nothing.
Yeah, it's incomplete, Mr. Washington.
I just heard that, Judge. I'm not sure what section is incomplete. I'll review it and we'll get that resubmitted within the next day or two.
She sent it back to you just a few minutes ago. She said she received the application today at 11:35 from you. And she said there was no case information on it. So she sent it back to you.
Okay, we'll take care of that. I'm not sure why she just got it today. We sent that 3 weeks ago, but we'll take care of it.
All right, so when do you want them to come back, Norma?
Can they come, well, How soon are you gonna do the paperwork?
Assuming that if she emailed it back to us, I'll get it to my client to us. It's not going to take much time to fill out paperwork.
All right, so Norma, today is Tuesday. Let's say they'll have it back to them by Thursday.
Did we freeze?
Yes, we did. So you're gonna need to get that paperwork back to them by Thursday.
This week, Thursday. Yes, ma'am.
Yes, okay?
And our court date would be Thursday?
Oh, no, we're gonna get the court date from Norma now.
Okay.
I guess we can bring them back in 30 days just to make sure it's done, Judge.
Okay, what date?
The 24th.
All right, we'll be back on August 24th.
We will see you guys then. We'll get the paperwork submitted by Thursday.
Okay, thank you.
Thank
You're
you.
both excused.
Thank you. Bye-bye.
And Norma, we need James Meyer.
Yes, ma'am.
And Gail Calderon is still in breakout room number 9 with Destiny. Does anyone want to go in breakout room number 9 and find out what's going on there? Who was the prosecutor who was working on that?
I talked with him earlier on a bond motion.
Oh, no, it's Gail Calderon.
Oh, I thought you said Miguel Nahara.
No. All right, Gail, what's happening with your client? You're on mute.
I spent a lot of time talking to myself. I'm sorry, Judge.
Yes.
She just wants to talk to her family. She's got a 6-year-old.
No, I mean, she needs to come to the main breakout room. She's still in number 9. I thought that was the whole thing, to bring her to the main room.
I thought we were waiting for you to come to there. That's why
No.
I'm
She
sitting
needs
there.
to
I
come.
am so
You know what?
proud.
I'm going to do this. I'm going to close the breakout room, so that should kick her out.
Okay, thank you, Judge. I apologize. I misunderstood what you said.
All right, no problem.
How are you?
Oh, I'm doing great. It's it's a beautiful Tuesday. All right, Ms. Cortez.
Good morning.
Good morning. Your attorney said you need some time to think about something.
Yes.
How old are you?
I'm 29.
All right, here's the thing. I'm going to give you the speech that I give everybody. You know what people need to start doing? Before they get in trouble, before they make a decision, they need to call people before they do what they shouldn't do. Here's an example for you. You have teenagers, and I think all the parents will appreciate this. Teenager wants to go to a party. The teenager knows there's going to be drugs there, right? So instead of, talking to their parents before, they sneak out, they go to the party, then they get caught. And then at that time, it's like calling their parents or whomever because they're in jail. I guarantee you, every parent would have appreciated, for example, calling the phone, and I'll just use this as an example. Mom, Brenna, I've been invited to this party. I would like to go. Let me give you some information. It's at 9 p.m. They're not going to be parents there. There are going to be a lot of teenagers, male and female, and there's going to be drugs there. May I go to that party? Now, I could be wrong, but I think Brenna's answer is going to be no. I think she would prefer that phone call than, excuse me, Mom, Brenna, I went to a party. I didn't tell you, but there were drugs there. There were, females there, males there, and we just got arrested. I'm at the Bexar County Jail. Could you come and bond me out? I'm pretty sure she would appreciate the first call to the second call. And she just says she's not bonding anybody out. So thanks, Brenna. So here's the thing. You're not a teenager. You're 29 years old.
Yes, ma'am.
So you should know what decisions you're going to make, because at the end of the day, these are your decisions. These are your consequences for your actions. And your mom can tell you whatever she wants to tell you at this point in time. Your friends can tell you whatever they want at this point in time, but at the end of the day, you're stuck with the consequences. Do you understand?
Yes, ma'am, I understand.
Brenda, you know what my grandmother would always tell all of us, and my mom would say, not going to jail for you. I'll be there for you, but I'm not going to jail for you. So is this going to be contested, Miss Calderola?
I don't know if she wants to connect. She wanted to discuss it with her family. And then if I could just get a short reset and give her a chance to talk to everyone, make arrangements. She has a 6-year-old daughter and she wants to make sure she has a place for her to stay. And that's really why she wants to talk to her godmother who's taking care of the child right now. This is her first.
Who is the 6-year-old daughter?
My godmother who raised me.
No, she said that you wanted to make arrangements to make sure your daughter is taken care of. What is the 6-year-old's name?
Evangeline Cortez.
Evangeline?
Evangeline Cortez.
Okay, is Child Protective Services involved? Because I don't understand why she would have a child when she's on deferred for injury to a child. And then I ordered intensive parenting classes. And then, of course, there's no contact with certain minors. But all right, this is what we're going to do. We're going to set this for a contested motion to revoke. If it turns out it's not contested, then it's not contested. But we're setting this for a contested. Ms. Ferguson? On Miss Destiny Cortez, I need a contested date, please.
1 second, Judge. Let me find it. The computer is just acting up.
Joe Ray, how many witnesses do you all anticipate with this?
2 at the most, Judge.
Okay.
I can do. I can do August 10th in the afternoon.
All right, August 10th at 2 p.m. That's your contested hearing date.
Okay.
Okay, thank you, Judge.
All right, thank you.
May I speak with Destiny just for a moment to get them?
All right, everyone, I'm going to open up breakout rooms. Do not go to a breakout room unless I specifically assign you. Ms. Cortez, if you go to breakout room number 8.
Okay.
All right, Norma, any update on James Meyer?
Yes, ma'am. He has a vacation letter on file, according to his legal assistant, and I'm looking that up. But
okay.
His client's supposed to be logging in.
All right, we will see about that.
I'm logged in. Paul Hernandez.
There he is.
Okay.
It looked like he was in the shower.
All right, Bo Woods, what's happening with your, Bo, you have the Olympic rings behind you. Did you hear the U.S. women's gymnastics team got the silver? Did I just ruin that for you, Bo?
No, but did you see it was her state of mind? I thought she hurt herself.
Yeah, at
Maybe
first I
it's gonna
thought she was hurt too. But you know, people expect so much from people, you know?
Right. And I'm sure she puts more on her shoulders than any of us.
Oh, yeah. And see,
now
that's
it's
what.
the greatest.
Hmm?
Well, now they say the greatest gymnast of all time. And it's like, God, leave her alone. Do that after you've retired.
You know, the reporters asked Venus Williams, how does she deal with, you know, the reporters, always saying negative things like you're not this good or that good. And you know what her response was? She's like, she's like, because I know their best day, they still can't beat me on the tennis court. So she's like, that's how I handle it. So I think people need to start saying, hey, you get on this balance beam and then talk to me.
Right.
Yeah, I
right.
want to see you do a cartwheel on this balance beam.
Do that triple somersault dismount.
Yeah. Oh,
Well,
and
my
Brenda.
client is Miss Laura, and she's come back on. I think we've done paperwork. Norma,
let me
did
see if
you
the
get
paperwork
the
is
paperwork
done.
from my client on Miss Laura?
Yeah, I still don't, let me see. I may have some paperwork. Yes, it just come in.
The clerks may need to swear her in.
Yes.
Yeah, I just need to swear her in really quick too.
All right, Bo, I'm going to send your client to number 2.
Thank you, Judge.
And Bo, the other thing I couldn't do is I could never do the uneven bars. It's too high.
A bunch of upper body strength for me.
All right, and Norma, who's going to be representing Jesse Solis?
He came in yesterday, Judge. It was Albert Rodriguez.
So what's the reset date?
It was August 23rd. He talked to him yesterday, Judge. He couldn't be
okay.
yesterday.
All right. Thank you. All right. And then Alfonso Cabanas on Adrian Garcia.
I will check on that, Judge.
Norma, I have this listed as August 4th on my file.
Cabanas' case?
Yes, it's supposed to come back on August 4th at 9.
Okay.
And on Brewer, what are we doing with Brewer?
We're doing paperwork right now.
Okay. And Mr. Weiss, how do you pronounce his last name, Brennan? Is that Weiska? We're going to bring you back at 2. All right, Gail Calderola, you're excused if you don't have anything else with us.
Okay, thank you very much, Your Honor. And if she decides to accept the offer sooner, can I notify the court?
Oh, yes, just let Ms. Ferguson know and she'll bring it over.
I will, Your Honor, and thank you so much.
All right, you're welcome.
A good one.
Gail, please let me know too.
I will. I'll email you, Joey.
Thanks.
I'll email you. Bye-bye.
Adrian Garcia, your case is set for August 4th.
Yes, ma'am.
All right, thank you. You're excused. Thanks for your patience.
Yes, ma'am. Thank you.
Only one team from the Olympics showed up with no masks. One from the Olympics. Kyrgyzstan. I think.
on Lada, can you see what the court paperwork is at?
Yeah, give me 1 second. Let me finish up this and then I can switch over. On Lana, it's in her email. Yeah. The email I have for her is Judge, I send you a chat.
Oh, yes, that's fine. Paul Hernandez,
Yes, ma'am.
we're going to recall your case for August 24th.
Yes, ma'am.
Get in touch with your attorney and make sure he's here, okay?
Yes, ma'am. Thank you, ma'am.
All right, you're welcome. You're excused.
Thank you so much.
And Norma, we'll need the other inmate, Mr. Viceka, back at 2.
Okay.
And his attorney is David Cuellar.
Okay.
He's 16C. And Norma, I think Mr. Brewer is gonna have to come back at 2. Because I don't think any of the paperwork has been done on that.
Okay.
Norma, on Bo Wood's client, we're just gonna have to bring that back at 2 because it's close to 12:30 already.
Yeah, I think Robert is printing out the paperwork already, Judge. Do you still want me to bring it back at 2 or?
All right, Brenna, are you okay to take this plea?
Yes. Yes, I'm good.
Okay, all right, this will be the last one, then we'll take our 2 o'clock. Hunter, are you handling this case?
Yes, ma'am.
All righty. Okay, and let me give you this. This is. Thank you. All right, court is calling 2021 CR 3421, State of Texas versus Danielle Laura. Can I have the parties announced for the record for the state?
Hunter Morris.
For the defense?
Bo Wood on behalf of the defendant. She's present. We are ready, Judge.
All right, Miss Laura, you need to unmute and have your driver find a stable location, please.
Yes, ma'am.
All right, are you Danielle Laura?
Yes, ma'am.
We're proceeding by video. Any objection from the state?
None, Judge.
Any
No, ma'am.
objection from the defense?
No, Judge.
Ms. Laura, I'm showing you a document entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily consented to appear by video. Next, I'm going to show you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case? And did you review that discovery with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Ms. Laura, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, I do.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Ms. Laura, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
Do you understand what you're charged with is driving while intoxicated with a child under 15 years of age? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counselor, has your client been able to provide you with any defenses to this offense?
No, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, ma'am.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Laura, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
The court will find that the defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on count one, asking that your punishment be assessed at 2 years in the state jail facility. There's a $1,500 fine, probated. There's no application for deferred adjudication. State recommends community supervision, and there's restitution of $60 for laboratory testing. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Judge, I want to address two matters in the plea, but that's correct.
All right. State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am.
Do you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counselor, are there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is asking that your community supervision be for a term of 4 years. There be a TAP evaluation, 120 hours of community service, restitution, parenting classes, DWI victim impact panel live, DWI intervention and ignition interlock for half the term. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the plea.
State offer states one and attachments, Judge.
We've had an opportunity to view it and have no objections.
All right, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments or review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge, we'd waive PSI.
Anything you want to say on behalf of your client?
I do, Judge. She has 2 small children. Excuse me, I didn't have that brought up here. Let me look at my notes. 30 years of age, has high school, went to the 9th grade at McCullum. She's currently customer service in a restaurant. lives with her parents, but she's got two small children, a 9-year-old and then a newborn. The 9-year-old was with her at the time. This newborn, earlier today, part of the problem we had on signing this is the newborn got shots, and all that baby wanted was to be back in mama's arms. That was the one thing she couldn't do. But she's in agreement. The two things I wanted to address, Judge, was the ignition interlock. She had submitted a signed affidavit, and so currently she's just using a device at home into which she blows, and we would ask the court to continue that rather than she does not have a car, nor is one made available to her. The other thing is she's been missing some of the blows because they wanted, I think, every 2 hours. So I filed a motion seeking to limit the number of times because she says, I missed that 3 a.m. one because I'm so exhausted with that newborn asleep. I'm just passed out. And she said, I've consistently missed that 3 a.m. one. So she's asking if we could adjust that to accommodate this newborn who's, when the baby sleeps, you sleep. And that's where she is right now. And Miss Laura, is that fair? Have I described that correctly? Is there anything you want to tell the judge?
No, sorry. You got
That's
it.
been the 3 a.m. feeding is the 3 a.m. blow in the device has been the one you've been missing?
Yes.
All right, and you're not driving now?
No.
And you don't have a car, and nor is one made available to you?
No.
All right, State. So how do you feel about her continuing with the portable?
No objection, Judge, if there's an affidavit of non-driving, non-operation. I prefer one of non-access also, as long as it's made a condition that she cannot drive or operate a motor vehicle not equipped with ignition interlock. I have no objection to the portable alcohol.
All right, and then he has a question with the blow. All right, State, are you okay with blowing every 4 hours?
Yes, Judge.
So here's my question, and I don't know if it's the $1 million question or not, but I read the police report. Why was she drinking and she's pregnant? Am I the only one person who knows that you shouldn't be drinking? And I think it's either Bud Light or Coors beer that was strewn on the roadway. Am I the only person who got the medical update that you shouldn't be drinking alcohol while you're pregnant?
I didn't know at the time, Judge.
Wait a minute, how old are you?
30.
So what are you saying? You didn't know you couldn't drink alcohol while you were
No.
pregnant, or you didn't know you were pregnant?
Well, I didn't know I was pregnant. I should have.
But why does it say then in the police report that you're pregnant? That's what it says in the police
I
report.
found out at the hospital.
Well, it says here you were 4 months pregnant.
Actually, it was 3 months, and like I said, I should have known, but I didn't at the time.
University Hospital staff stated Danielle Laura was going to be admitted for further evaluation as she was observed to be 4 months pregnant. So this wasn't the hospital doing some tests and says, oh my God, she's pregnant. They're saying you were observed to be pregnant and you've had children before. So you would have known that you were pregnant. You know, it's neither here nor there, but I'm just saying, I don't think I'm the only person who knows that you're not supposed to be drinking alcohol, at least to the point of intoxication. Definitely not to the point of intoxication while you're pregnant. Because whatever you do to your body, you do it to the babies. It's like smoking cigarettes when you're pregnant. And am I the only person who knows this rule?
No, Mom, I understand what I did was wrong, and it's never going to happen again.
And she did go through a CPS case, Judge. In fact, when this case started, I think the guardian was listed, and she informed me that's actually the CPS worker. I wrote the name down here. Yeah, I think the guardian was listed as Caitlin Lovegood, and she said, yeah, that's my CPS worker. But that case was completed, what, in February?
Yes, Mom. Yes, sir.
All right. And are you still with this boyfriend you had to go drive to see while you were intoxicated and had a juvenile in the car?
Actually, he was at the hospital at the time. He has heart condition failure.
No, it says that you were driving to Pleasanton to see him. It wasn't saying that you were driving to see your boyfriend in the hospital. So are you still with this boyfriend that you were driving to see?
On and off. He sees his son, yes.
All right. Sometimes both people don't know what's important. All right. So are you employed?
Not at the time because of the COVID. I don't go out until I go to the doctor for my son.
So who's supporting you?
Actually get Social Security from my daughter. She's disabled. I live with my mom and my dad.
All right, that Social Security is supposed to be for your daughter. It's not for you to support you. You understand that?
No, I do understand that, but I need a roof over my head and I need to do that somehow.
Are you receiving food stamps?
Yes, I am.
So that means that the taxpayers are supporting you. So here's the thing about taxpayers. Yeah, we'll support you because we're supporting children. Do we want to do it? No. But will we do it? Yes, because we're compassionate. But you're going to get a job while you're on this probation. You understand?
Yes, ma'am. I've had a job since I was 16. This is the only time I haven't had a job.
Yeah. Well, we're going to make sure that you have one. Court is going to sentence you to 2 years in a state jail facility, suspended and probated for 4 years, $1,500 fine, probated, restitution of $60 for lab testing, 120 hours of community service restitution. How far did you go in school?
Up to 9th grade, and then they gave me a court order to go out, and I started working at Church's Chicken when I was 16.
All right. I don't know why they wouldn't have you get your education, but it's going to be 120 hours of community service restitution. That'll be waived if you obtain your GED or some sort of trade school or higher level education.
Thank you, Judge.
Parenting classes, and Bo, if she's completed parenting classes through CPS, that will be acceptable. CPS compliance, if applicable.
Thank you again.
DWI Victim Impact Panel. In-home device in lieu of ignition interlock. No driving. Affidavit of non-driving to be presented. Proof of employment within 40 days. No employment as a home health care provider or supervision of minors. Random UAs. Random field visits 2 times per month. Regular reporting by Zoom. If your Zoom doesn't work, you'll have to report in person. Rebecca, is there anything else that she needs?
No, ma'am.
Miss Laura, is there anything else you need from the court in order to be successful?
No, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, sir.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, we can go off the record. So your newborn child, is it a girl or a boy?
It's a boy, my first boy.
Okay, so let me say some things to you, and this is what I would always say to my clients when I did child protective services cases. Now that you're a parent, children come first, because they cannot support themselves, they cannot take care of themselves, all of that, right? So here's the thing about having boyfriends, men who have girlfriends in their life. You can't have boyfriends and girlfriends roaming in and out of your children's lives. And let me just tell you why. Because you don't know them. And once you bring a girlfriend or boyfriend into your children's life, your children are not going to be able to protect themselves. And however those persons treat you, your children are going to think it's okay to treat people that way. So I'm telling you this because you're responsible, remember, for two people who cannot protect themselves. They're 100% dependent on you to protect them. So this boyfriend that you told me about, who's in and out of your life, he can't be in and out of your life because your children need stability. And honestly, if he's not bringing anything to the table, then you probably shouldn't be with him. And what do I mean about bringing things to the table? People say they're in love. We're in love. It's so great and grand. But at the end of the day, the person that you have in your children's life need to bring something to the table. They need to bring the appetizer or the entree or the dessert. If they're not bringing anything like that, you shouldn't probably have them in your children's life, because what's going to end up happening is you're going to have a CPS case. You understand?
Oh, no, Judge. Yes, I understand, but that I guess the in and out is well, not what I meant. He does support the child. He buys everything for the children, even his not other child. So the only reason I don't stay with him is because I rather stay with my mom. My sister, like not even a year ago, she stabbed her. So I've been helping my mom with my nieces, and yeah, so I rather stay with my parents to help them. But
here's the thing, keep an eye on your children. That's all I'm saying. You understand? All right, I'm going to send you to a breakout room. I'm going to send you to breakout room number 1. Mr. Woods, you can go to number 1 or you can be excused. They're going to go over conditions with her.
Thank you, Judge.
You're welcome. And everybody, we're going to stop live stream. We're going to come back at 2 p.m. to finish up our